Got this, as we mentioned a moment ago. Former FBI Director James Comey did appear for that arraignment. Alexandria, Virginia, a moment ago, pled not guilty to these two charges that the Justice Department has now laid against him, accusing him of lying to Congress. Want to bring in Andy McCarthy here. It was a short hearing, as to be expected. Do you believe the government has a case, Andy? And if so, how strong?
I don't believe they have a case, Bill, based on what we've seen in the indictment and what we know from the public reporting. But now we're going to find out. You know, the arraignment was apparently unexceptional and unremarkable. That's usually the case. The only thing that really happens is a plea gets entered. But now the real work begins. The judge will set a schedule for the filing of motions. I expect that Comey's team is going to make motions, particularly about selective prosecution and that sort of thing. And the judge will have to rule on that. And if the case doesn't get thrown out prior to a trial date, we'll have a trial.
All right, folks, so that is conservative lawyer and top Fox News legal analyst Andy McCarthy once again breaking Donald Trump's heart and the heart of his MAGA co-hosts Bill Hemmer and Dana Perino, and probably the MAGA audience at Fox News, by standing 10 toes down on business, saying that Donald Trump's prosecution of James Comey is legally meritless. And again, he goes so far as to say the damn thing should be tossed out. Not only should it not have been brought in the first place, the judge should dismiss it due to its lack of merits. And not only did he say this sort of stuff once again on Fox News, Donald Trump's favorite channel, he continues to write about it at the National Review, which is an even further right publication than the Wall Street Journal. And we have to talk about this. But before we do, if you end up liking this video and you want to support the channel, please be sure to hit the like, subscribe, and alert bells before you go. All right, friends, I want to play the rest of this exchange between McCarthy, Hemmer, and Perino, because you can all, Hemmer's not on camera at the time, but you can hear him like deflate like a balloon in real time when Andy McCarthy continues to say, this doesn't look good for Trump.
Andy, listen, either James Comey told the truth or he didn't, right? I mean, that's essentially what it comes down to.
Yeah, well, but it gets more complicated than that, Bill, because, so there's 2020 testimony, which refers back to 2017 testimony. And what Ted Cruz's questions seem to be about when you go back to the transcript of the 2020 testimony is whether Andy McCabe had authorization. McCabe was the deputy director of the FBI. Whether he had authorization from Comey to leak a story about the Clinton Foundation that the FBI was investigating to the Wall Street Journal. And the circumstances are that even McCabe has said that Comey didn't authorize him. He didn't discuss the matter with Comey until after the story was out. So it's unlikely that McCabe could be this person three who Comey authorized to leak stuff to the media, according to the government. So they've started to look at other people. But I think when you look at the other people that they have centered on, the problem is at the time that there were leaks from, for example, from Comey through Dan Richman of Columbia Law School, neither Comey nor Richman was an FBI official, and the stuff that was leaked was not about Hillary Clinton, which is what the indictment says. So I just think that factually they have a very difficult time making this case. And let's not forget, the U.S. attorney who Trump had put in the first place, Eric Siebert, who evidently was a good enough U.S. attorney in terms of the Trump enforcement program, that Attorney General Bondi and Deputy Attorney General Blanche went to the president to try to persuade him to keep him in place. He was the one who didn't want to bring this indictment. I don't think he didn't want to bring it because he has any great fondness for Comey. I think he didn't want to be responsible for signing off on an indictment that they might not be able to prove.
That's brutal. That's just brutal. I mean, it really is. Again, this isn't like a liberal. This isn't a liberal lawyer. This isn't Eric Holder, former Obama Attorney General. This isn't Merrick Garland, former Biden Attorney General. This is one of the most respected, well-known conservative attorneys. He is a Fox News stalwart. Megyn Kelly, as deranged as she is, continues to say she deeply loves, admires, and respects this man who says that what Donald Trump is doing here is insane and meritless. And you could hear, again, Perino was off camera at the time, but you hear her go, like acknowledging what Andy McCarthy is saying here unhappily. She's not happy about this because she wants Trump's lawfare to succeed, as they all do. So it helped that in the past 24 hours, McCarthy wrote up some very short breakdowns of recent Comey case developments. So let's take a look. Comey case developments, the perp walk that wasn't. As our James Lynch reports, former FBI Director James Comey was arraigned in a Virginia federal court this morning, entering pleas of not guilty to the false statements and obstruction charges in the Trump administration's indictment. And then again, as he said, arraignments are usually brief. The prosecution of Comey is an unusual case, so as we might have expected, there were some developments worth noting. I'm going to take them up in 4 posts, starting with this one. Let's start with the perp walk, or lack thereof. There was online chatter over the weekend anticipating that Comey would be arrested and perp walked. That did not happen, and it was highly unlikely to happen, notwithstanding Donald Trump's social media post demanding a perp walk. Even by Trump standards, this was remarkably foolish. As we shall see, Trump is basically writing Comey's motion to dismiss the indictment based on selective prosecution and political vindictiveness, which he discusses towards the end in the 4th part, I believe. It has been widely reported that Comey was issued a summons to appear in court, originally on October 9th and moved up to this morning. Rule 9A of the Federal Rules of Criminal Procedure calls for the court to issue an arrest warrant when an indictment is returned, meaning agents may hunt down the defendant and take him into custody. But there's an exception. The court may issue a summons, a more benign directive that allows the defendant to voluntarily appear in court for his arraignment, but only if the prosecutor asks for a summons instead of an arrest warrant. When I was a prosecutor for the Southern District of New York, it was customary to have the court issue an arrest warrant. That's the rule preference, and it doesn't prevent the prosecutor from agreeing with the defense counsel that the defendant may surrender voluntarily rather than be apprehended. I don't know if the Eastern District of Virginia follows a different practice. As we've noted, Lindsay Halligan, the former insurance lawyer and White House staffer Trump installed as interim EDVA U.S. attorney, has never prosecuted a criminal case before indicting Comey. Based on Rule 9A, I have to assume she agreed to the issuance of a summons rather than an arrest warrant, even if she asked for a warrant and the request was denied. I have not seen that reported. And remember, Halligan was Trump's pick to replace Eric Siebert, and again, he was the one that McCarthy mentioned at the end of that clip, which is like, this was a Trump appointee, Eric Siebert, very experienced. Trump put him in that position. Siebert's like, hey, we don't have a case to make here against James Comey. We probably shouldn't bring charges. And Trump yanked him out of office and effectively fired him. A summons is a demand to appear in court. If, after the president's perp walk post, the Trump Justice Department had suddenly asked the judge to issue an arrest warrant so they could parade him around in handcuffs and leg irons, that would have looked terrible. Trump officials don't often seem concerned with the look of things if they happen to be things Trump desires, but trying to arrest and perp walk Comey under these circumstances would have been suicidal for Halligan in court in terms of her standing with the judge and other judges. No one knows this better than Donald Trump. As abusive, remember, this is a conservative legal analyst, a Fox News lawyer, so he hates the Democrats and thinks that, the Democrats engaged in lawfare against Trump. So keep that in mind, right? As abusive as much of the Democrats' lawfare campaign was against him, in each case, though he was not in office at the time, Trump was permitted to surrender and be processed rather than arrested and cuffed. I presume after this morning's brief court appearance, Comey reported to government officials to be processed by the FBI in the court's pretrial services division. All indicted defendants go through that procedure, and there is no requirement that the defendant be placed under arrest if he has agreed to be cooperative. So there you have McCarthy slamming efforts by Trump and Kash Patel and others demanding that Comey be perp walked. So the second post, the January 5th trial, despite DOJ requests for more time. By all appearances, prosecutors are not eager to try this case. There are good reasons for this. See here and here. The judge set a rapid schedule befitting the EDVA's well-earned reputation as the nation's rocket docket. Trials to commence less than 3 months from now on January 5th, 2026. The government unsuccessfully argued for more time, claiming the case is complex. False statements cases are tough for prosecutors, but usually not complicated. You prove the statement made and prove why it was knowingly false. Moreover, when the government has waited until the tail end of a 5-year statute of limitations to bring charges, prosecutors are in a poor position to claim they need extra time to get their ducks in a row. Unsurprisingly, the judge declined to delay matters. Not good for Trump again. Post number 3, insufficiency of the indictment. And this is one of the 2 more meatier ones. As predicted, the indictment's defects in serving its primary constitutional purpose of providing notice of what the defendant is alleged to have done is already a big issue. In furtherance of the Sixth Amendment's mandate that the accused be, quote, informed of the nature and cause of his accusation, the Rule 7C1 of the federal criminal, I can't remember, we just read it, the criminal rules of, what was it? What was it? Oh, I blanked on it. The Federal Rules of Criminal Procedure. I was going to say criminal police. That didn't sound right. Okay. The Federal Rules of Criminal Procedure dictates that an indictment, quote, must be plain, concise, and definite written statement of the essential facts constituting the offense charged. Yet, Comey's lawyer, Patrick Fitzgerald, informed the judge that the government has not revealed to the defense the identities of person 1 and person 3 described in the indictment. To recap, it is alleged that Comey, while FBI director, quote, authorized someone else at the FBI, end quote, to serve as an anonymous source for news reports about, quote, an FBI investigation concerning person 1. Though the poorly written indictment is not totally clear at this point, it appears that the FBI official Comey allegedly authorized to leak information is otherwise described in count 1 as person 3. Although it's puzzling that the government has not confirmed this for the defense, we can be reasonably confident that person 1 is Hillary Clinton. That's because there is reference to person 1 in a false statement charge that the grand jury declined to indict that appears to pertain to Clinton, i.e. person 1's, quote, approval of a plan concerning person 2 in the intelligence in the 2016 U.S. presidential election. This appears to be a reference to intelligence reporting about Clinton's approval of her campaign strategy to portray Donald Trump, presumably person 2, as a Kremlin collaborator. Plus, in false statement count, the grand jury did approve, the reference to person 1 pertains to Comey's alleged lie in response to questions posed by Senator Ted Cruz about an FBI leak regarding his probe of the Clinton Foundation. Okay, so reasonably confident about who person 1 is. Person 3, however, remains a mystery. That's a due process problem because person 3 is the key to the prosecution's case. The FBI official supposedly authorized by Comey to leak to the press. Most speculation about person 3 identity has centered on 2 possibilities. Former FBI Deputy Director Andy McCarthy and Columbia Law Professor Dan Richman, a former FBI contractor. Without belaboring what I've already detailed, neither of them is a good fit based on relevant reporting. Fitzgerald elaborated, quote, we haven't been told precisely what is in count 1 or count 2, the false statement obstruction charges. The latter seems to depend on the former, vaguely alleging that Comey obstructed Congress by providing false testimony. It's fair enough to observe that the defendants habitually complain that the government hasn't given them sufficient notice. Here, though, we can read the indictment for ourselves and find that it raises more questions than it answers. Would anyone really be surprised if, in the Trump DOJ's case against the president's arch nemesis, the DOJ has been less than forthcoming about additional information? It's very hard for defendants to get an indictment dismissed based on the ground that it's been insufficiently pled. Despite Rule 7's above-quoted mandate of clarity, courts tend to uphold an indictment if it provides the approximate date of the alleged offense and minimally sets out the statutory elements of the offenses charged. The elements are the facts that the prosecutors must prove beyond a reasonable doubt to establish guilt. The rationale for declining to dismiss sparse indictments pretrial is that if the defendant needs more information to prepare a defense, the indictment can be supplemented by a bill of particulars and other discovery. Here, the indictment informs the defense that Comey is alleged to have lied and obstructed at a Senate hearing on September 30th, 2020. Fitzgerald, however, that's again Comey's defense attorney, said could have a persuasive argument that while the indictment tells Comey what statutory offenses are charged, it does not lay out the elements in a way that coherently describes Comey's alleged lie. After all, how can he defend himself against an accusation that he authorized a subordinate to leak if the Justice Department refused to tell him who the subordinate allegedly is? On this score, I repeat my earlier caution about the risk the Trump DOJ has run by waiting until the tail end of the statute of limitations to file charges. Normally, deficiencies in an indictment can be fixed by obtaining a superseding indictment from the grand jury. But if the limitations period has already elapsed, as this one did last week, it is impermissible for the government to supersede in a way which materially changes the indictment. To allow that would be, in effect, to allow a new charge. At this point, any new charge arising out of the September 30th, 2020 testimony would be time-barred. That's a lot. One last thing here, okay? This is the fourth of Fox lawyer Andy McCarthy's smackdown, 4-part smackdown of Trump on the National Review. Selective vindictive prosecution motion is coming. Finally, defense counsel Pat Fitzgerald has also informed the judge that Comey would be filing a motion to dismiss the indictment on the grounds of selective and vindictive prosecution. This is also a very tough claim for a defendant to prevail on. Successful motions are exceedingly rare. But James Comey has a lot more work to work with than most defendants. To win such a motion, the defendant has to establish 2 things. Number 1, the prosecution was motivated by a discriminatory intent that targeted the defendant based on some impermissible factor. And 2, similarly situated individuals, as to whom that impermissible factor does not apply, have not been charged. Historically, the usual impermissible factor is racism or some similar characteristic. But the selective prosecution claim often does arrive in the political context. An opponent of the incumbent administration claims to have been singled out for prosecution due to that opposition. Often, it's not difficult for a defendant to show that the incumbent administration had animus against him, and in a politically charged case, it's often logical to conclude that the animus stemmed from a political rivalry, which, like racial, ethnic, or religious bias, is an impermissible basis to charge someone with a crime. Still, that showing can be a dead end if there's evidence that the defendant actually committed a crime. In our system, the executive branch has discretion regarding who does or doesn't get charged, and courts are not permitted to substitute their judgment for the prosecutors. If there's real evidence that the defendant committed a crime, courts won't be very moved by claims that the government doesn't like the defendant for other reasons. On the other hand, if the evidence of guilt appears scant, the defendant's showing of an impermissible motive can take on more significance. That said, where selective prosecution claims tend to founder is over the other factor, whether similarly situated people haven't been prosecuted in situations in which the impermissible factor is not present. Usually, there's just not evidence of that. If, for example, the government routinely prosecutes various people for the crime charged against the defendant, it becomes nigh impossible for a defendant to prove that he's been singled out. Here, by contrast, Comey is going to be able to establish that he was indicted A only after the president publicly chastised the attorney general for that failure. And by the way, put a pin in that because we've got a story for you which dovetails quite nicely with this. Put a pin in that and check in later. To that point, to charge him, B, that Trump had called for Comey's prosecution in the context of similarly calling for prosecutions against other political opponents, and while unabashedly insisting that they deserved it because Trump feels these political opponents unfairly charge him, and C, after publicly celebrating Comey's indictment, Trump, as discussed in the first of these 4 posts, became insistent that Comey be perp-walked because Trump ally Roger Stone had been perp-walked, lending credence to the conclusion that the case against Comey is a vindictive effort to put him through a punitive process. Moreover, Trump has pardoned many political allies who were charged with or convicted of making false statements and or obstruction. Michael Flynn, Paul Manafort, Roger Stone, George Papadopoulos, and Alex van der Zwaan were all pardoned by Trump after being charged with or convicted of making false statements to investigators or obstruction. To be clear, I am not opining about whether these individuals were guilty of mendacious and otherwise obstructive conduct. I had plenty to say about that, generally sympathetic to the defendants when those cases were ongoing. The topic we're just, again, remember, he's sympathetic toward these people because he's a Fox News lawyer and conservative. It's so important you guys understand this. This is not a liberal or progressive. This is the top Fox News lawyer guy going, this is insane. And I love Trump, or rather, I'm sympathetic to Trump. The topic we're discussing now is selective prosecution. On that point, what matters is whether the others were charged with the same crime, not whether they were guilty. While not convicted of obstructing Congress, Steve Bannon was convicted of criminal contempt of Congress for failing to provide testimony and other information, and he was pardoned by Trump. And of course, Trump granted pardons to over 1,600 Capitol riot defendants, many of whom were charged with obstructing Congress. Comey is uniquely situated to argue that, number one, Trump unmistakably singled him out for prosecution on the impermissible ground that Comey is a political enemy, whom Trump blames for smearing him in the Russiagate probe. And number two, Trump's political allies, who were charged with crimes similar to those Comey faces, got discriminatorily favored and favorable treatment, even if the evidence against them was substantial, while Comey has gotten discriminatorily unfavorable treatment against him despite dubious evidence of guilt. Okay, so that's Andy McCarthy laying out why this is such bad news for Trump. And I'm sorry we had to go through all that, but it's so important. This is not just some random schmuck. This is a celebrated, respected, deeply conservative, pro-Trump, or at least Trump-sympathetic, quasi-MAGA lawyer, beloved by major MAGA figures like Megyn Kelly. And he's like, this ain't it, Chief. This ain't it. In the meantime, let me know what you think in the comments.